Sorry for the confusion with the two meetings, folks. I think we have it straightened out now. Let me just do a sound check. Can everybody hear me?
I can. Can you hear me okay?
I can.
Yes. Can you guys hear me?
We can. All right. And the judges have already checked it, so we should be able to hear everybody. What I will do is ask if you are not speaking, please mute your microphone. So we are here for oral argument in IC 20-0017, Casa Grande, Arizona versus Benzing. We are recording these proceedings. And so I'm going to ask that you please give your name and name your client when you begin. You are obviously arguing from remote locations. Again, I will ask you to mute your phone or your device when you are not speaking so that we can try to avoid any feedback. If you get in a situation where you cannot hear us or get in a situation where we cannot hear you, something has gone awry, do your best to let us know. We're trying to watch that as well if the screen freezes, and we'll let you know if we're having any trouble on our side. But if you have trouble hearing any of us, please do the same. You have a maximum of 20 minutes per side, though you are not required to use all that time. Use your time as you choose. We do require that you keep track of your own time. We don't have clocks on the screen or on podiums here in this virtual world. What I will do is my best to tell you when you are at 10 minutes, 5 minutes, and 2 minutes. But again, you're responsible for keeping your own time as you go along. And so if you have a question on how much time you have left, ask, and I can also tell you that in addition to the signposts. Please keep in mind that we have read all the briefing. We did study the record, and we did discuss the case in conference earlier today. And so with that, counsel, you may proceed.
Hello, this is Steve Baker for the City of Casa Grande and Arizona Municipal Risk Retention Pool. And I'd like to reserve 5 minutes in rebuttal, if I could, please.
You may, and you're responsible for keeping track of it.
Thank you very much. I believe the administrative law judge erred in assuming that if the injured worker requested an uninterested party to attend, that she essentially, in this case, had to because of what she noted in her decision upon review were constitutional concerns that I don't think apply. I believe the applicable statute is ARS section 23-941, and I believe that under my interpretation of the statute, industrial commission hearings are not open to the public. I believe that industrial commission hearings are open to the interested parties, which are defined in ARS section 23-90110 to include the employer, the employee, the industrial commission, the defendant carrier, and the attorneys on behalf of the parties.
Counsel,
sure.
If I can, because you said that you believe they're closed to the public, but what statute says they are closed?
I'm relying on 941. It does not specifically say they are closed to the public, but my interpretation of the statute indicates because they only refer to interested parties in being provided with the notice of the hearing, being given the right to subpoena witnesses, being given the right to notice the judge, being given the right to file a request for a review. And none of those powers, as far as I can tell under the statute, are delegable to non-parties.
Well, counsel, isn't that true of every lawsuit? Every lawsuit, the parties get notice. Every action, the parties have the right to notice. All of those things are rights that belong to the parties, but not every lawsuit is therefore closed to the public because the public doesn't have the same rights as parties.
It's interesting. The only thing I could find that was somewhat analogous, although not completely analogous, is depositions, which I believe under the case law, and I'm talking about civil depositions, which under the case law, only the parties can attend absent good cause. And when you read the, again, the statute doesn't specifically say this, but what I'm envisioning, the statute's envisioning, is that this is a dispute between the employee and the employer to which the public isn't an interested party. And what I'm envisioning under the statute is that the only people that are going to be attending this hearing are the interested parties. And I think what the idea was behind the statute was to have a relatively quick, efficient, to-the-point process that could be handled quickly, and our hearings are usually handled relatively quickly compared to the civil arena, with minimal costs, minimal interference.
So in that regard, if the statute doesn't say they're closed, the statute does, however, say that the ALJ is the one in charge of how these proceedings go and the things that you were just talking about, the efficient hearing of the evidence, the efficient processing, basically has control over the courtroom, doesn't it?
She does, and he does. And I believe the Court of Appeals generally gives the judges wide latitude in how they conduct a hearing. But again, the way I'm envisioning the way the statute was meant to be applied was that these hearings are not open to the public. And generally speaking, I think the common practice followed that idea. For example, in this case, Mr. Benzing requested permission to have a non-party attend. He just didn't automatically assume that a non-party could show up for the hearing, which is how we've always done it. And we've usually, what usually has happened is if someone requests a non-party to attend, the parties either object or don't object. And in the past, what has happened is that, for example, if you wanted a staff member to attend a hearing for educational purposes, the other attorney might agree, the other attorney might not agree. And then we abided by whatever the objection was, and it never has been an issue before. Generally speaking, if someone objected to a being present, the non-party wasn't allowed to attend. This hasn't come up very much because no one really wants to go to an industrial commission hearing. And the judges have usually treated them as not open to the public, such that we don't have newspaper people attending. We have never had a politician attend a hearing as far as I know. So again, the way I'm reading the statute is that unless the parties agree that a non-party can attend, that's the end of the story. If, however, if I'm mistaken, and this is more analogous to a deposition, and again, the way the courts have interpreted depositions is that this is a pre-hearing process that's only interested, that only the parties themselves are interested in, and absent good cause, non-parties can't attend. So if that's the course that the court believes is a better course, where there's a balancing, there has to be some kind of showing that there's a good cause for the non-party to attend. And I think we've listed as best we can the reasons why we don't think that in this case, the senator has a legitimate interest that would allow that to overcome the privacy rights of the expert and any lay witnesses.
Counsel, do you have any case that says an expert witness has a privacy interest?
The only thing I can rely upon is just the general Attorney General's opinion that notes that the privacy interests include their education, their training, their experience, their salaries, and that generally that kind of information shouldn't be disclosed without good cause to the public or to non-parties. And that is, generally speaking, the authority that I have that talks about a balancing of interests.
And that case actually talks about claimant's interests. That opinion, that is focused on claimant's interests, not expert opinions or experts or anybody else.
I will agree with that, but I don't see why the reasoning would apply only to the injured worker when you have, let's just say, lay witnesses, for example, involved. Certainly a lay witness has privacy expectations such that they shouldn't be subjected to having non-parties privy to their background, their training, their education experience. If that applies to lay witnesses, then I don't understand why it wouldn't also apply to expert witnesses. I don't think that, as a general matter, that the hearing should be open to anyone without a weighing. My concern with the judge's decision is I don't think she, in her ultimate decision on review, she didn't weigh the interest. I think she assumed that there was a constitutional requirement that she allow the senator to attend, and I don't think that's correct. I think that she needed to, if a weigh-in is required, to actually explain why the interests of Senator Boyer outweigh the interests of any lay witnesses who are going to attend or any experts who are going to attend. I can't hear.
Mr. Baker, explain to me again the privacy interests that an expert would have in his or her credentials and educational background. I mean, my understanding is a lot of these individuals post their curriculum vitae online. They're certainly available for hire. They're proud of their credentials and rely on them and want the public to understand them. So explain to me the policy that you're advocating for providing some sort of confidentiality for materials that these experts don't consider to be confidential at all.
What we've run into at the Industrial Commission in the past, for example, is attempts to find out from the experts how much they're earning per year in expert fees. And we've had situations where there's attempts to find out exactly how they conduct their IMEs. And I think there is a privacy interest that an expert has in not having published to the public what his annual salary is, for example. And we've run into situations, and I think you've also run into this in civil cases, where there's questions concerning exactly how far you can go in the discovery process and at what point in time that oversteps the need to know as opposed to the privacy interests.
Well, but don't you think that those are limited areas that the ALJ can handle on an issue by issue basis as opposed to a blanket prohibition?
You may very well be right. I read the statute as a blanket prohibition against non-parties attending without an objection. If you read the statute differently, then I still think there has to be a weighing of the interest, and I don't think the judge did that in this case. Again, in her ultimate decision upon review, the way I read it, she simply concluded that there was a constitutional interest at stake which she couldn't override. And I don't think she actually balanced any privacy interests against allowing the senator to appear. If you remember, there was some mention by the respondent about, well, perhaps we could tailor it a little bit. The judge could say that certain information isn't disclosable, or the senator can't attend certain portions of the hearing. And the judge wouldn't consider any of that. She said, no, that's prior restraint, which I don't understand the reasoning on that. And so she didn't actually balance or take into account the respondent's suggestion as to how to balance the privacy interests.
And just a couple of follow-up questions, if I could. Has the hearing actually been set, the date?
No, it has not been reset.
Can I interrupt for just a second, Jared? About 9.5 minutes.
All right. Is it your anticipation that this hearing will proceed on a virtual platform as opposed to in person?
As it stands right now, probably.
And as I understand it, the parties have agreed that the union representative can attend.
Yes, the applicant indicated that he considered him a family member. He didn't have any family. And so I indicated that I had no objection to this individual who the applicant regards as a family member to attend.
And explain to me then the basis for your objection as to Mr. Senator Boyer as opposed to the union representative.
Well, again, if it was a family member, there would be, then I would not object anytime to a family member attending, just for moral support. The applicant indicated he needed the union representative there for moral support. That seemed to me to be a sufficient reason to allow a non-party to attend, just in my opinion.
But under your interpretation of the statute, the family member shouldn't be allowed to attend either.
No, the way I interpret the statute is that if a party objects to a non-party attending, then the objection should be allowed. What I'm saying is that these are proceedings not open to the public unless the parties agree that they're open to the public.
So, Mr. Baker, so seems like what you're suggesting here is that the parties have all the discretion here. The ALJ has none.
the way I am interpreting the statute, you are correct. If you are interpreting the statute to allow the judge to have discretion as to who to admit, then I think there has to be a balancing of the privacy interests.
But let's go back to allowing the union rep here. What is the difference between having the union rep discuss matters that go on, I mean, that might share those things to the public, and having Senator Boyer do the same thing?
Well, the difference is that because of the senator's position, quite frankly, if you remember from the opening brief, something that I've never seen happen before is we got a letter from the Attorney General's office to the judges saying that they weren't taking into account the first responders' interests in interpreting the statute and applying the statute at the hearing level. Then we got a request that the senator be allowed to appear at the hearing who had written the statute, and with the idea being that the reason he needed to attend so that he could better understand the hearing process. My concern was, and the city's concern was, is that it seemed as if there was some improper influence being exerted against the judges to perhaps encourage them to interpret the statute more liberally than they were. And I wanted to ensure that the city got a fair hearing. And my concern is that having the senator together with the AG's letter was beginning to give the appearance of impropriety in someone attempting to improperly influence the outcome. To protect my client's interests, I suggested that we not allow the senator to appear, because my concern is that put too much undue influence potentially on the judge. It made my client uncomfortable that they were not potentially getting a fair hearing.
Counsel, you're at
So
5
that's the
minutes.
difference. That's the difference between allowing someone who the applicant said was like a family member to them, and because he does not have any surviving family members, that was the difference. Not so much the information that the family member might disclose, although his bully pulpit would probably be less than the senator's. So I'm at 5 minutes. I'll answer any questions if you'd like me to stay on. Otherwise, I'll reserve what I have left.
That appears to be fine if you would move. Mr. Whitley?
Thank you, Your Honor. May it please the court, my name is Nicholas Whitley. I am one of the attorneys that represents Mr. Benzing, a firefighter with the city of Casa, Grande. The ALJ in this case used the Attorney General's opinion properly as guidance and effectively used the case law and balancing test therein. The interests, and especially the privacy interests of the parties, were weighed. The objections of the petitioners were weighed. The ALJ explicitly found there to be no undue influence and that the petitioners did not have a satisfactory reason to disallow Senator Boyer to view the hearing process. The ALJ absolutely applied the balancing test and has ruled correctly, and we would request that this court affirm that order and the decision upon review.
And counsel, is it your position that the privacy interest is only as to Mr. Benzing? Or are you conceding that the city has some level of privacy interest?
I believe based on the statute, our position is that the overwhelming privacy interest is with the injured worker, because it's especially their medical information that could become public. It is their educational work history, those other things too, but it is their medical information, which is supremely private. So the position that the only interest lies with the injured worker is probably not correct, but I do think it greatly outweighs any privacy interests. And as your honors were asking Mr. Baker, you know, the doctors and the expert witnesses put out a lot of their information into the public eye already, so their expectation of privacy seems to be weak.
So, Mr. Whitley, let me ask this question. Why is it important that Senator Boyer actually attend to this hearing, whether it's in person or by virtual platform? Why isn't the educational goal he has here, why isn't that fulfilled by simply giving him access to the transcript once it has been prepared?
Well, Your Honor, that was accomplished. Mr. Benzing followed the AAC rule, which lets him authorize a party to review those transcripts. But as this panel knows, reading a cold transcript is very different than being in a courtroom, hearing and seeing live testimony. it is our position that Mr. Boyer, Senator Boyer, would learn about the process, about where his previous bill is coming up short by being in the hearing room, seeing Mr. Benzing testify, as we noted, that hasn't happened yet, seeing the expert witnesses testify, and these experienced attorneys ask them questions about Mr. Benzing's cancer. And we think that being in the courtroom for that is invaluable. Just like when you guys try to read a cold record, you don't get some of the detail out of that. You don't get to see the demeanor. And while Senator Boyer is not evaluating the credibility, the fact finder certainly is evaluating the credibility and the demeanor of witnesses. And we think that that would pass along to Senator Boyer if he is allowed to be in the hearing room.
Mr. Whitley, how far could this go, or this notion be taken of the right to attend? I mean, would you continue to go up the food chain as far as public officials, the Attorney General, the governor, making those requests to appear at workers' compensation hearings? Where would the lines be drawn? Or even say, what if not just one senator wanted to attend, but 10 senators, or the entire committee, an entire committee of senators, or the Speaker of the House and the Speaker and the President of the Senate? What parameters are there to provide some reasonableness to these types of decisions?
I think that's a great point, Your Honor, but I think that we do avoid the slippery slope here. Senator Boyer is uniquely positioned. Mr. Benzing was uniquely positioned. There have been other cancer cases that have come up after Senator Boyer's original bill. Then Mr. Benzing's case came up. At the time, they did not know each other. At some point, it was discovered. Mr. Benzing then asked specifically for Senator Boyer to be allowed there because Senator Boyer is the one who authored the original presumption bill for cancer and is trying to author another one, as the courts have continued to interpret it, and it is a very hard path for firefighters to succeed. So this is a very unique circumstance, and then I do think that the balancing test is the correct test. So while it may be case by case, the next ALJ in a different case would weigh the factors, whether it's the defense or the petitioners in this case requesting a party to attend, or whether it is the injured worker and their counsel. The ALJ would make a balancing of the interests and would make a decision, and we would trust the ALJ to do those things correctly.
So basically, is it your position that as we look at this, as long as the ALJ does the balancing test, if we were to impose such a requirement, that really this is a case where if the ALJ had said no to Mr. Boyer, you would say we would affirm as well? That, as long as the ALJ balanced the interests and came out to that, as long as it wasn't an abuse of discretion, it would be okay?
Again, I think that the worker has a much stronger privacy interest than the expert witnesses. So if the ALJ had denied this, I don't know that I would say we would not have appealed, because Mr. Benzing is the one that is at risk for all of his private information becoming public. So I think that there's a strong argument there that it does weigh slightly more in favor of the applicant, because so much of their information comes into the record and gets talked about throughout the hearing process. But yes, I would say that the balancing tests and the discretion of the ALJ, as Mr. Baker pointed out, that the section 23941F gives them great discretion in how to conduct their court, but it also, at the very end of that section in F, says that it in a manner that will achieve substantial justice. And so here we believe that substantial justice not only affects Mr. Benzing's case, but if Mr. Boyer, Senator Boyer, can understand the process better in these new proposed bills of a presumption statute, it could have the larger effect of substantial justice for other firefighters and first responders.
So let me ask then, so I understand, had the city been the one to invite Senator Boyer for some reason, and because of, he drafts different legislation, you could easily envision that the city might have that interest. would we be looking at a different test then? Is that what you're saying? That it's different when we have the waiver coming from the employee as opposed to the employer?
I don't know that it's different, Your Honor, but it is part of the balancing test, and I think the overwhelming weight of the privacy interest does lie with the injured worker. If I may, Your Honor, how much time?
12 minutes.
Okay, thank you. I believe that we've also discussed already that the doctors put out their CVs, and indeed Dr. Schumacher appears in other appellate cases in Arizona as a testifying expert, and Dr. Zarnecki appears in other appellate cases in Illinois, as well as presenting at the 2019 Annual Workers' Compensation Seminar, where his CV was part of the materials. So it is our position that the privacy interest really does rely in a much greater sense with the injured worker, with Mr. Benzing, and it is Mr. Benzing who has requested this. It is Mr. Benzing's goal to potentially help Senator Boyer understand the process and be able to write a better bill, one that will actually fulfill the purpose that it was intended to. In closing, Your Honor, in analyzing the law and using the Attorney General's opinion as guidance, the ALJ has effectively applied the case law and the balancing test here. The interests, and especially the privacy interests, were weighed, and the ALJ found no undue influence, and that the petitioners do not have a reason to disallow Senator Boyer from viewing the hearing process. The ALJ applied the balancing test, ruled correctly, and we request that this court affirm that order and the decision upon review. Thank you.
Thank you, counsel. Mr. Baker?
Thank you. I believe that petitioner and respondent agree that as a general proposition, industrial commission hearings are not per se open to the public. I would argue that I would go further and say they're not open to the public absent consent of the parties. But if you're going to say that the statute allows the judge to conduct the hearing without non-interested parties, then I think, again, it needs to be reiterated that as a general proposition, the hearings are not open to the public absent good cause. And I don't think good cause exists here, and I would put the burden on the party seeking the non-party to attend to show the good cause for the non-party's attendance, whether it be moral support or something along those lines. I don't think that there's a legitimate reason for Senator Boyer to be present at the hearing. He's already redrafted two of them, attempts to create an irrebuttable presumption that if you're a firefighter under certain circumstances and you get cancer, if you meet the requirements, your cancer is work-related. I don't understand what attending a hearing as opposed to reading the hearing transcript adds to an understanding of the law in this area to write an irrebuttable presumption statute. I guess one of the concerns I would have as a practitioner in this field is I don't want to start having cheering sections at hearings with the employer having room in their side intimidation. In this case is the city's interest in a fair hearing. And again, the concern I have is that when you have the AG writing the judges, putting them on notice that he's concerned they're not giving fair responders a fair shake, together with Senator Boyer's request to attend the hearing, the first time that's ever happened, as far as I know, creates an uneasy feeling in the city, and I think the city is entitled to a fair hearing absent what appears to be some impropriety here. So again, I don't have
Isn't
much
that addressed, though, counsel? Isn't that issue
Pardon me?
addressed? Isn't that issue addressed? The ALJ said that the ALJ felt no intimidation, did not feel any concerns about having him there. So do we protect the uneasiness in this fairness concept if the ALJ says there is none?
I think it's always been in our ethical rules that we avoid even the appearance of impropriety. And that would be my concern here, is that I think there's the appearance of impropriety. Whether it's there or not, the judge says it's not. So we'll accept it's not. But it appears that there is some. A reasonable person could look at this and say, wait a second, is someone trying to predestine the outcome here? And if that is a legitimate concern, which I think it can be in a case like this, then what the judge should do, in my opinion, say under these circumstances, I'm not going to allow any outside parties to attend so that everyone understands that they're getting a fair shake. I'm about out of time. I'm free to answer any questions. Otherwise,
about 2
I have
minutes.
nothing else. I have nothing else to add unless there's questions that I can answer for you.
All right. Judge Winthrop, did you have one?
No, I don't. Thank
All right, thank you. We will take the matter under advisement and issue our ruling in due course. And we're going to ask you folks to please disconnect. And I'm not certain how I kick you out of the room, so I'm going to ask you to do that.
All right. Thank you very much for allowing us to appear virtually, and hope everyone in Nick's office is okay.
All right, I did figure out how to do it. So I think they're both removed.
Okay.
I found the button. I knew there was one and I just hadn't looked at it.